Please be seated. This is the time set for oral argument in Kennedy versus Wheeler. Mr. McDougal.
Please support. We don't have to deal with many exhibits on this one. It's not factually complicated, but it's it's of extreme importance to the state of Oregon. We've got a unique jury system that's got, perhaps in the world, some unique characteristics in the evidence standard. And now the question is, do we really get 12 jurors? Or do you only have 12 jurors until after the first question, and then you only have 9? Because we are disenfranchising jurors in Oregon. It's that simple. We go all the way back to Clark versus Strain, which every case relied upon in Clark versus Strain has been overturned, and Clark versus Strain has been implicitly overruled by Ulrich, Ververes, and Schwartz, Philip Morris. So, where are we? This particular case, you can resolve it on the larger scale. Well, do we disenfranchise jurors? Or you can say, are we going to split the hairs on the dependent-independent basis, or economic damages and non-economic damages dependent on each other? A little hard to go there, I think, under the current state of the law, because punitive damages are much more dependent upon compensatory damages than the relationship between economic and non-economic damages. And we've already said that punitive damages, you can have a separate verdict. You sort of roll into the bigger issue of when can you bifurcate a trial and how can you bifurcate a trial. If you stick with Clark v. Strain, how can you reconcile it? It's antiquated, it's outlived its usefulness, and it's already been implicitly overruled. The next question you have, which I'm assuming someone will get to, is what about the law of the case that the Court of Appeals relied upon? Well, when I don't object to a jury instruction, or even
let me ask you this before you get to that part of it. The constitutional provision that we're looking at here only talks about what's necessary for a verdict. So what's your argument in terms of the language of the constitutional provision as to what that means?
I believe in our brief we cited other state constitutional provisions that were similar where the court said, well, it means 3/4. 9. It doesn't say on every single question. It says 3/4 of the jury. And if you want to give jurors power, I mean, after all, you're taking away from their daily lives, you're subpoenaing them into court, you're paying them a pittance, and when they get there, you tell them how important their role is. And what do you do to them? Well, if you vote no on number 1, you get to sit and watch. 3/4 means 3/4. It's how jurors have understood it. Non-lawyer jurors.
Well, 3/4 is 3/4, but back to the question, what's the verdict?
3/4 of what?
3/4 of what? Focus on that.
May render a verdict.
What does the verdict mean when, what does the verdict mean when, as here, you've got question 1, which has one, you have to answer, and then there is question 2, which has 2 parts. What is the verdict? Is it the whole thing or part of it?
As commonly understood, the verdict is the whole thing.
Well, so you have a verdict form that has 3 separate claims in it. It's one verdict form, and it's got, 11 questions for the jury to answer. You just need 3/4 of what?
Well, if you're the Ververes court, you'd say for each claim you need 3/4. If you're another court, you'd say, well, if it's punitive damages, you don't have to have the same 3/4. 3/4 means 3/4.
Well, so what are you saying is the answer to my question? 3/4, if you have, hypothetically, you've got 3 separate claims, right? And there may be, I don't know, pick the number of questions, doesn't matter. Do you need, in your view, under the state of Oregon law, 3/4 on each claim, 3/4 on each question, 3/4 on something else?
When you say, in my view, under Oregon state law, it's not my opinion. I'll tell you.
This is not a trick question. I'm just asking you, what are you advocating for us to do in that hypothetical situation?
Let me answer it in 2 parts. One, first, I'm advocating that Oregon current law says that you only need 3/4 votes on questions that are dependent of each other. Okay? I'm advocating that you only need 3/4 votes on anything dependent or not dependent, because otherwise you're disenfranchising jurors. And if we're going to address this issue, we might as well address it.
Okay, then what I want to know is what does that mean? Because I don't understand what that means. When in the context of my question, where you've got 3 claims and 11 questions, and you say, I just need 3/4 on anything, what does that mean in the context of my hypothetical?
On any question on the verdict form, you only need 9 out of 12 to answer it.
And it doesn't matter who the 9 are.
That's correct.
Right? That's your view.
That's my view, because just because you vote against liability doesn't mean that you're not very well suited.
It makes a lot of sense. I don't know if it's right, but there's a reason. I mean, you make a good argument in terms of jury participation at a jury of 12 because you voted one way on one. You voted against liability, but everybody, there were 9 votes for liability. Now you can vote on damages, right?
Yes, that's what I'm asserting.
So if you have a special verdict that breaks out negligence and specifies negligence causation separately, you can have different 3/4 on each of those questions?
Yes, because I'm going to assume that every juror can follow the instructions, even if they vote against somebody on a factual finding. The mere fact that you answer no.
You don't need to go there to win this case,
right,
though, you would say, right?
I agree that, but if we're going to be here discussing it, why not clarify it for everyone?
Oh, yeah, but sometimes you want to make sure you win and not sort of make a good argument and lose.
Let me revise that. Right. As long as I win, why not clarify it?
But in terms of that clarity, when we require a unanimous verdict in a criminal case, we require unanimity on, speaking of, I guess, unanimity, you're always going to have. Unanimity.
Well, 10. We require 10 on a non, other than first degree or aggravated murder.
And in that regard, I did point out in my brief, I know I did it to the Court of Appeals, I don't know if it is the Supreme Court, but you've got a number of criminal cases where you're supposed to have unanimous, but then you talk about harmonizing the verdict and upholding it.
You mentioned the assumption that jurors are going to follow the instructions. That leads back to the question where you were going, I think, which is what you had labeled law of the case. I'm not sure if that's the right label, but there is this problem that defendant raises that the trial court instructed the jury, you didn't object to it. Is that not significant?
Not objecting is not the same as stipulating. Trials are always moving targets. The rules change as you go along. If I had stipulated, I'd be in a much different position. Plaintiff's counsel did not stipulate. What you've got is you've got defendant arguing, well, you cannot waive the invalidity of a verdict under the cases they want, but you can waive the validity. I don't think that, if you think about it, judges are sworn in. If they know they've got a valid verdict, can they simply waive it? I mean, when this judge caught it, he said, you know what? I think this is valid. Can you say, well, since you didn't object, Mr. McDougal, it's going to be invalid, and forget the fact that we took all these people from their homes and that they've got the constitutional empowerment to vote and they did a valid verdict. Because Mr. McDougal went with the uniform, that's out the door.
How does the instruction itself here play into this in terms of the language of it?
In my mind, it plays in 2 ways. One, the jury was let go. We'd be in a much different position if defense counsel had stood up and made it very plain to the court what the problem was. The court said, oh, he's saying there's not 8 of them. There's not 8 of them. It's not till after the jury's gone that the court understands exactly what defense counsel's objection is. If defense counsel had made an objection that the court understood, the court would be well within its power to say, you know what, I'm going to re-instruct this jury on the voting rights. And you'd say, wait, does he even have to because he's got a valid verdict?
I have to say, when you're hearing that, I'm wondering if it's sauce for the goose, why not sauce for the gander? By the same reasoning, if you had said something to the trial court could have clarified the instruction, and we wouldn't be here. I'm going to put aside any question of whether that's preservation or law of the case. Just as a practical matter, if you had said something, the trial court could have avoided an erroneous instruction and avoided this appeal, couldn't it?
It could, but who's the guardian of the integrity and power of jurors? Is my failure to speak fatal, or does the court have a higher role? Does a judge?
Well, how far do you take...
Can my failure say, oh, sorry, jurors, you got a valid verdict, but I'm just a failure?
Well, how far do you take that? That reasoning seems to claim too much. if the logical conclusion of that is that nobody needs to object to a jury instruction contrary to ORCP 59 because the courts are the guardians of the quality of jury instructions regardless of the failure of lawyers to complain about them.
There's a difference for me getting something substantively wrong and there being something procedurally wrong because my relationship to a juror and a juror fulfilling its constitutional duties is much different than my relationship to the court and trying to advise it to the law. There's got to be some place at which you say, wait a minute, we're going to respect a valid verdict. Just like you say we're not going to respect an invalid verdict.
Was the instruction, I'm sorry, was the instruction here inconsistent with the constitutional provision involved here?
Yes, I believe so.
In how so?
So one, by disenfranchising voters. Two, by not incorporating the case law saying that you don't have to have the same 9 votes on elections that are not dependent upon each other.
I think the OTLA argues that the instruction is actually kind of confusing and might be consistent with not having to have the same 9.
The instruction is confusing. This jury obviously thought it was following it and came up with the verdict they came up with that ended up being, by our view, a valid verdict.
Or one juror forgot how he or she voted.
There's explanations, yeah.
You mentioned the distinction between sort of substantively improper instructions and procedurally improper ones. Are there cases that support that distinction?
I'm just basing it on common sense and the duty, the respective role of the court in relationship to a jury versus the other regard.
So what's the difference? I'm not sure I understand the difference between a substantive instruction and a procedural instruction. You're talking about burden of proof. Is that substantive?
No. Let me see if I can articulate it on the fly here. I couldn't come in and tell a court, there are some things I can suggest and urge on a court that even if they're convinced by me, it's not right. They can't do it. And that would be if I was to come in and say, well, this is the way the jury has to be. This is the way the voting has to be. No, that's not right. That's not what the Constitution says. My urging doesn't override. I can't disenfranchise jurors by my urgings. That's what the judge is there to prohibit me from doing.
I take it if Mr. Stockton had persuaded the judge you needed 11 jurors to agree for a valid verdict and you get 10, and so the judge throws it out, your point would be you wouldn't be bound by the 11. You could look and say there are 9 jurors. It's a good verdict, no matter the fact we didn't object to the instruction.
Correct.
And so I take it, in your view, as long as you acquiesce in an instruction that procedurally asks more than what, in your view, the jury is required to do, and you can tell from the face of the verdict that it's okay, that's not a problem.
That's correct. I mean, I think I have to stipulate if I'm going to get away from the constitutional requirements for a jury. I don't think that I can disenfranchise them by just going along with the uniform instruction.
And maybe you would say you can't even stipulate to something that's not constitutional.
That's a whole different question. I know people do it. Am I here today to say they can? I'm not so sure you could stipulate to make an invalid verdict valid, just like you can't stipulate to appellate jurisdiction. But we don't have to go quite that far.
You can waive pretty much any constitutional right, right?
I can waive a constitutional right, but can I waive their right to vote? I'm taking them out of their life. I'm getting them together. Can I say, oh, I'm going to waive your right to vote?
Right. Could the parties agree to have an eight-person yes for a valid verdict? Probably not.
Why? But why not? Why not? If both sides knowingly say, I know the Constitution requires 3/4, but I say 8's good, and you come back with an 8-person verdict, why wouldn't they be bound?
That's you don't need to decide
I mean, I guess the Democrats and Republicans could say, we're not going to let certain people vote and agree to it.
Well, but that gets at an underlying issue here that you're characterizing this as protecting the jury's rights as opposed to protecting one party's rights or the other party's rights to have a constitutional verdict. Depending on how you characterize that, different conclusions flow. And I've never heard of anybody arguing that under the Constitution the jury has a particular right. It's usually characterized in terms of what the party's rights are.
Well, I am arguing that the jury has particular rights with the disenfranchisement.
But you're still saying this was not the hypothetical that we're kicking around. You say, look, we didn't stipulate to this. We didn't. This is different here. We didn't raise an objection. We didn't have to raise an objection to this.
Right.
So if, for example, the trial court had recognized, for the right reasons in your view, that this instruction was erroneous before the jury was discharged, the trial court could have said, we're going to fix that, and we're going to give a correct instruction, even if there had been no objection by the plaintiff to the instruction in the first place. Is that correct?
That's correct. I don't think the trial judge I think he's got an inherent duty to fix it if he knows that this is wrong. I'm not faulting this trial judge.
So this is complicated a little bit by the fact that maybe it didn't happen exactly that way, but what I hear you saying, leaving aside the question of whether the jury is disenfranchised or not, is in effect that's what happened. An erroneous instruction, the effect of an erroneous instruction was not visited on either the jury or the plaintiff by the trial court's ruling.
And if he had understood the objection, he could have just fixed it right there and we wouldn't be here. The fact that he fixed it after the jury left the room, if his reasoning is correct, it shouldn't make any difference.
Does it make a difference that the state of the law is such that it may support the instruction the trial court gave? In other words, does it put a greater obligation on the party? It's one thing if the law is clear that, in fact, you don't need 11 people to agree in a civil jury on a verdict. But what if it's not clear that, in fact, you can have, say, independent voting, so different 9 on liability damages? Does that place a greater obligation on the party that thinks the accepted law is incorrect to raise that with the trial court? Or can they say, oops, I can show you retroactively that was a valid verdict and I'm good?
I think in our legal system, we do that. We say the Constitution provides this and we're going to apply it. And looking at the level of advocacy of a particular plaintiff in a civil case to see whether or not they had the constitutional right might be a little awkward. I mean, the Constitution provides what it provides.
We have all kinds of appellate cases requiring the preservation of constitutional issues.
Right, but who's preserving it for the jury?
Well, that gets us back to the
gets us
idea
back to jury rights, and I think you shouldn't argue that. But
If in this case the plaintiff, the court had said, oh, I understand what you're saying. You're saying the same 9 have to agree on both, on the 2 sets of damages, and they didn't. It looks like we've got a problem. I'm going to send them back and tell them to redeliberate until they get the same 9. And if the plaintiff didn't object to that, are you saying the plaintiff could come back in and say, uh-oh, it was valid at the beginning?
I wouldn't put it past myself, to be honest.
I wouldn't put it past you either.
But we don't have that factual scenario. In fact, we have what's more likely would be the court. I don't need to send you back because it is a valid verdict, because the court reached that pretty quickly. But the other scenario, I don't want to prejudge the situation. It would depend.
Other questions? Save your time for rebuttal, then?
Yes.
Okay, thank you. Mr. Stone? Mr. McDougal, rebuttal?
Just one clarification. The trial court did get it right for the right reason. On page 22 of the transcript, Judge Tishner says that I do not find that economic and non-economic damages are dependent upon each other. They could have, et cetera, et cetera. I'm not going to read the whole thing, but that's page 22. So he did find the right reasons down below for upholding the verdict. When it gets to the practicality of how to proceed, or at least we know the current rule is confusing. A very simple rule is any 9 does it. Anybody can understand that rule. Any 9 on any question. Then you're not going to have confusion. You can play out what if they vote no on liability? How's that going to go to damages? Well, that's why people deliberate, and the people deliberating with that person know how he voted on damages.
Yeah, but if you have a claim and the claim consists of 3 elements, A, B, and C, and you have one group of 9 agree on A, and then one of them, and then a different group of 9 on B, because one of them says, well, you know, okay, fine, I don't agree with A, but if there's A, then I'll agree that the other elements have been proven. The bottom line is you don't have the same 9 people agreeing that the claim was actually proven. That's what underlies the rule on the criminal side, that you need to have jury concurrence on all of the elements of the offense so that you can get a jury of the required number agreeing that the offense has been proven. Why doesn't the same reasoning apply to civil claims?
I don't know the origin of the reasoning, other than it's just historically been there. 9 people is 9 people. It's 2/3. It's 3/4 of the jury.
But I mean, maybe I'm not being clear. The claim consists of a certain number of elements, and unless you have the same 9 people agreeing on the elements, then you haven't got the same 9 people agreeing that the claim has actually been proven.
Right. That's presupposing that the same 9 languages in the Constitution, I guess, is the difficulty with answering.
Well, it sort of depends on a lot of this would depend on what the verdict form is like.
Right.
Do you break out these elements, and that's how we, end up with these cases where we say, well, what did the jury mean here? Because we'd ask, interrogatories, special interrogatories, or special verdicts were asked, and they end up being inconsistent.
Yeah. So let me ask you, I understood Mr. Stone to argue that even if we were to agree with you on the Constitution, you may be giving up more than he would, but even if we were to agree with you on the Constitution, in his view, the statute or the rule that require 3/4 of the jury to concur in the verdict embodies the same 9 rule. That's sort of the backdrop against which those things were adopted. And whatever we might think about the Constitution, he says I win on the statute or the rule that now takes its place.
That's like having no, it's a bridge. The Constitution trumps the statute.
Well, the Constitution doesn't prevent requiring the same 9. It may not require it, but I don't know that it prevents it. And so could the legislature be more protective of verdicts and say we want to have the same 9, even though we don't have to?
Not if you agree that they're being disenfranchised. I don't think the legislature can disenfranchise votes that the Constitution allows.
Okay.